In a video posted January 2nd, 2025, an individual who we will refer to as Mr. Watchman pulled into a parking lot of the Johnson Police Department in Fayetteville, Arkansas to take a business call. When he exited the roadway, he drove around the back side of the building before parking in a lot adjacent to the department. A short time later, Lieutenant Sterling Halfhill noticed Mr. Watchman's vehicle in the parking lot and made contact with Mr. Watchman. Portions of the interaction that unfolded next were captured on both officer body cam and Mr. Watchman's personal dash cam. Mr. Watchman's dash cam activated shortly after Lieutenant Halfhill initiated contact, with more officers arriving minutes later.
Is it a stop and ID state?
We are stopping and IDing you.
Are we a stop and ID state?
I can't hear you.
Are we a stop and ID state?
I can detain you for suspicious activity.
Sure.
Yes.
You can detain me. Would you like to detain me?
Why are you here?
Do I have to have a reason to be here?
Well, you have to have a reason to be in our parking lot, and you have to have a reason for why you're driving behind, up there next to our stuff.
You mean when I circled around the parking lot?
Yes, sir.
So I have to have a reason to circle the parking lot?
If you're in the police parking lot, we need to know why.
Okay, what law is that? What law is that?
It's suspicious activity.
Sure. And suspicious is a misdemeanor or a felony?
I'm not trying to confront you as far as a misdemeanor or a felony. That's not what I'm trying to do. It's suspicious activity.
Sure. Suspicious
so we're
is a misdemeanor or a felony?
It's not a misdemeanor or a felony.
Okay, then it's not a crime, is it? Suspicion is not a crime.
You're in the PD parking lot.
Are you a sergeant?
I'm a lieutenant.
You're a lieutenant?
Yes, sir.
So what?
So you're here to confront police officers.
I'm not here to confront. I was here talking on the phone. I was here talking on the phone. You came up to my car. You came up to my truck to do what? ID me. To ID me for what?
To respond to suspicious activity in our parking lot.
And what suspicious activity do you have me doing?
You're in our parking lot, which is
sitting here talking on a phone.
Not supposed to be here.
I'm not supposed to be in this parking lot? I'm not supposed to be in this parking lot.
About
who did the complaint?
One of our city workers.
Okay. So is this a public parking lot?
This is not a public parking lot.
Where does it say private property?
Right over here.
Over here on this side?
Drove through.
No, it says do not enter police vehicles only. It does not say private property.
Okay, I'll agree with you there.
And it does not say it on that side where I came in.
Okay, that's fine.
So I am not being suspicious. I'm having a phone conversation in a public parking lot where I'm allowed to have a conversation where I don't have to drive on the road and have a conversation.
You do.
And I do business in Johnson.
Just not here.
I will be here as much as I want to be here.
Okay.
What's your badge number?
My name is Sterling Halfhill. I can give you one of my cards if you
Please
like.
do.
Okay.
I'm done with your conversation.
I'm just asking. Do you have a problem with law enforcement?
Temple, can you fax that? And fax that return for the owner.
I'm just curious why you would sit here and argue with us. Suspicious activity in our parking lot. You understand what's going on in the world today. You know, there's some activity that's happening. So if there's suspicious activity that we get a call, right here. If there's anything that happens throughout our little area here, especially in the PD parking lot, if there's suspicious activity that we are aware of, we're going to identify the person that's on the parking lot. That's it.
Again, I'm going to repeat myself.
You can repeat yourself. I'm just saying, why do you want to argue?
So, the thing is, we can't trespass them off of government property.
But what I'm asking is, why do you want to make this so
difficult? No, I do. You did. I was talking
on
the phone
because I cannot do my job.
I roll my window down, and I told you I was talking on the phone.
So
you couldn't wait 1 minute. You kept saying, "Roll down your window. Roll down your window."
I was doing business on a public parking lot. You stopped what I was doing and tried to ID me for suspicious sitting in a parking lot talking on a phone on a public parking lot.
We have a job to do.
Well, good for you.
We'll continue doing that job.
Good. I'm not stopping you from doing your job. I'm not stopping you from doing your job.
We do this
you
job
don't
because
have
we want
a
to make
right
sure everyone's
to
safe.
ID me.
I did.
You do not.
You can ask anyone In law, I had a right to
You
identify.
do not have ID. You do not have the right to ID me.
say that all
I
day
did
long.
not break the law.
Lieutenant Halfhill insists that Mr. Watchman is lawfully obligated to identify himself, and Mr. Watchman disagrees. Under Section 3.1 of the Arkansas Rules of Criminal Procedure, an officer may only detain an individual if they have reasonable suspicion that the individual has committed or is going to commit a felony or a misdemeanor that could cause injury or property damage. Furthermore, Arkansas also has a specific statute for compelling identification under Section 5-71-213 of the Arkansas Code, which is the state's loitering statute. This statute criminalizes the act of lingering, remaining, or prowling on both public and private property without an apparent reason and under circumstances that would warrant alarm. But it also includes a clause that outlaws refusing to identify or provide an explanation in that circumstance. In order for an Arkansas officer to lawfully compel a citizen to identify themselves outside the context of a traffic stop, the officer must obtain reasonable suspicion of either a felony, a dangerous misdemeanor, or a violation of Section 5-71-213. It would be difficult to make the case for the act of pulling into a parking lot and parking in an orderly manner as constituting a felony or dangerous misdemeanor, especially considering that Lieutenant Halfhill explicitly stated that Mr. Watchman was being detained for quote-unquote suspicious activity and not any felony or misdemeanor crime. Now, as for the loitering statute, simply parking in a parking lot generally does not warrant alarm or safety concerns, and Mr. Watchman clearly informed the officers that the reason he was in the parking lot was to conduct business on his phone. However, this analysis changes entirely with the introduction of a potential trespassing charge, which we will discuss in a moment.
I did not break the law. Unless you are charging me with what's your RAS? What's your RAS?
I'm not answering any more questions.
Yeah, because you don't want to, because you know I am right.
I'm telling you.
What is your RAS? Reasonable, articulate.
This is what's going to happen. You're either going to stop and leave, or you're going to get arrested.
I'm not going to stop and leave.
John.
What?
He would like to trespass me from this property.
I'm asking him to leave. He's not.
He'd like to trespass me from public parking.
Are you a First Amendment auditor?
I am not a First Amendment auditor.
Then why are you pushing this issue?
Because I know my rights and I do not have to ID for sitting in a public parking lot that is not marked.
You really want to go to jail because you won't leave and just go to another parking lot.
Would you like to arrest me, sir? Would you like to arrest me for sitting in a parking lot?
He doesn't want to listen. He's not obeying the law.
You just try to open my door.
So?
You can go ahead and write me a trespass.
You are not obeying a lawful order.
You can write me a trespass. You have to trespass.
I'm telling you.
So you're going to arrest me.
If you don't want to leave and not obey a lawful order,
it's not a lawful order.
Arrested.
It's not a lawful order. Tell me what the law is.
The lawful order.
Tell me what the law is
you're
that
not
you're
listening to me.
Sir,
that's not a law. That's not a law.
Lawful order of a law enforcement officer, it is.
No, I'm not. I'm not doing anything illegal.
You're getting
Is your body cam on?
You're getting yourself into a lot of trouble.
No, you're getting yourself in a lot of trouble.
You're under arrest.
Sir, you have to
Step
give
out
me
of the
a
truck.
written,
You're under arrest
you
for
have to
trespassing.
give me a written trespassing.
You're going to get a written trespassing.
Mr. Watchman argues that the parking lot is public property that he cannot be trespassed from, and that the officers are required to provide him with a written trespass warning before they can lawfully arrest him for trespassing. Now, before conducting any legal analysis, it is important to note that all three entrances to the parking lot that Mr. Watchman was parked in were clearly marked with signage designating the area as a restricted area for authorized personnel, dating back to at least 2019. And the path that Mr. Watchman allegedly took to enter the lot has the largest and most conspicuous signage of the three entrances. As mentioned in many previous episodes, this almost certainly rendered the parking lot as a non-public forum, where certain constitutional rights are significantly reduced. Under Arkansas Code 5-39-203, a citizen commits criminal trespass if they purposely enter or remain unlawfully on the premises owned by another. Arkansas Code 5-39-101 defines enter or remain unlawfully unlawfully to mean entering upon premises when not licensed or privileged to do so, or remaining on the premises after being personally communicated to leave by the owner or another authorized individual. Here, the signage put Mr. Watchman on notice that he was not licensed to enter the lot, and Lieutenant Halfhill personally ordered him to leave. On those facts, there is a strong argument that officers had probable cause to arrest for trespass once he refused to leave. And while Arkansas does provide a formal written notice procedure in Section 5-39-304, that statute is not a requirement for an on-scene trespass arrest when a person is already on restricted property and has been told to leave. That said, even if the trespass basis was valid, Mr. Watchman still would not have been obligated to identify himself merely because officers demanded it. The obligation would typically arise at the point of a lawful arrest and booking, not as a freestanding rule during every encounter.
Get out of the vehicle. We're telling you now.
Okay.
Get out of the vehicle.
Sir?
No. Get out of the vehicle.
Okay. I'm getting out. No, you cannot remove my stuff from me. Sir.
Step out of the truck.
Sir.
Step out of the truck.
Okay, he's holding my arm.
Okay.
He's pulling me the opposite direction,
Let him
guys.
go. Come here. Come here with me.
Hey,
Let it go of him. I got him, Halfhill.
I'm not resisting.
All right. Good. Good.
I'm not resisting.
Good. I know you're not.
Resisting.
We see that.
Do you have
I'm not resisting.
Do you have a weapon in the truck?
Yes, I do.
Okay.
I have my carry permit. It's
Yep.
right here in this.
Hand
Bible.
behind your back.
Okay,
Okay.
I'm sorry. I'm sorry. You can give me a written trespass, and I will leave.
You should have left when I told you to. It was a lawful
Sir.
order. No. We're done talking.
Sir.
We're done talking. You're going to jail.
You guys really want
You
to
should
do
have
this?
listened when we
Hey,
told you.
I think we should call someone.
Oh,
that's
you're
got a
gonna
little
have
bit
to call
higher
someone.
power. What's your supervisor?
Right there, Chief.
Chief, can I have a word with you?
We'll talk later.
No, I need a word with you.
We're done talking right
I just am sitting in a parking lot having a phone call.
now. 2 days in a row?
Yes, listen, come here. Come here, Chief, please. Chief, please. Please have a word with me.
Where was your weapon at?
You should have listened when we gave you an opportunity. I gave you a long time.
I did not listen.
You're going to come over here.
You just didn't like that I said no, that I wasn't going to leave.
No, I didn't mind you saying that. And
So
I
what
had a
was
conversation with you for
You
a
got
long period of time. I gave you
No,
every
you irritated
option.
me that I cannot talk
You're going
business.
to jail today.
Sure, take me to jail. But I'm going to tell you, my attorney is going to love that you're violating my
When you
First
get a
Amendment.
lawful order to leave, you
No.
have to leave.
No, I don't. Not on public land, sir.
Step in.
Make sure you pat him down.
Yeah. Good.
I have nothing on me.
Truck keys.
Yes, sir.
Check his cuffs.
Hey, I'm just gonna have. Can I have a conversation with you guys?
His cuffs. Make sure they're not too tight.
Can I have a conversation?
Check this cuffs.
Hey,
You're
I'm
doing
just
it.
gonna. I know you
Can I have
guys
a
are just. It looks like you're. I manage this complex right behind here. I use this spot so I don't have to go and park where my tenants come out and say anything to me.
Is it
I
the
was
one
having.
on Hewitt?
No, it's on Johnson Switch. I manage all that. I come over here and sit so I don't have to sit where tenants come out and harass me while I'm talking on the phone. And then your lieutenant came out and told me that I had to leave a public parking lot that's not marked public, that's not marked do not parking. I park over here so that I don't bother anybody over there. You have limited space in the front of your parking lot. You have limited space. I use the top to turn around. I have no ill will. I have nothing. I just sit here. He got mad that I didn't want to ID because I don't have to ID. I did nothing wrong. I had committed no crime. You're trespassing me on property, public property, and with no crime. I was not disorderly. I did not do anything wrong. I'm telling you, this is going to be a lawsuit, and I don't want to do that to Johnson Police. You guys have taken care of such good care of me at Johnson Switch. You're always there. If I call, you always take care of issues. I'm not trying to do anything bad. He demanded that I stopped my business conversation to have a conversation with him. He couldn't wait 5 seconds from me. He kept telling me to roll down my window and made me hang up my phone call that I was doing business. I am not bothering any of the employees. I'm not even
What's his
part.
first name? Hey, so I'm gonna go talk to the lieutenant.
If you arrest me,
at the end
everybody,
of the day, though,
everybody, if you unhandcuff
those two are my superiors.
I'm telling you, though,
so.
it's going to be a lawsuit against all you because I am going to call my attorney immediately. You're trespassing me. You detained me illegally for no reason at this point. No reason.
Right now, and if you would, I will.
You better go have a conversation with them, I'm telling you. And that chief better come talk to me right now, or I will have my attorney at this office today. If you are searching my truck right now, you're searching my truck. It's a search.
Hold on, man. Just relax.
I'm telling you,
I know what you're saying.
This is illegal.
I know what you're saying.
No,
let them
he
let
does
them do some
not.
talk.
It's your lieutenant.
After the officers handcuff Mr. Watchman and lead him away from his truck, they search Mr. Watchman's vehicle without his consent. However, even if the officers possessed probable cause to arrest Mr. Watchman for trespassing, that does not automatically authorize a search of his vehicle. In the 2009 Supreme Court case of Arizona v. Gant, the court held that officers may search a vehicle incident to arrest only if the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search, or if it is reasonable to believe that the vehicle contains evidence of the offense of arrest. Well, here, Mr. Watchman was handcuffed and secured in the back of a patrol car when the search occurred, and because the arrestable offense was criminal trespass, there was essentially no reason to believe evidence of that offense would be found inside the vehicle. Furthermore, the only other plausible justification for a warrantless vehicle search would be a limited protective sweep for weapons under the precedent set in the 1983 Supreme Court case of Michigan v. Long. However, this exception requires specific, articulable reasons to believe that the suspect is dangerous and may gain immediate control of a weapon, and is designed to be limited in scope to that particular safety concern. Well, considering that Mr. Watchman was already handcuffed and led away from his vehicle when the search began, it would be difficult for the officers to invoke this exception. Accordingly, Mr. Watchman would likely have a strong argument that the search was unlawful and violated his Fourth Amendment protections.
He lost control.
Just relax.
I'm telling you,
I know what
this
you're
is
saying.
illegal.
I know what you're saying.
No,
let them
he
let
does
them do some
not.
talk.
It's your lieutenant. He lost control.
Again, they're my supervisors.
I understand, sir.
I know what you're saying,
you're
too.
protecting blue right now instead of protecting the law.
I know exactly.
My constitutional rights are being violated.
I know what your rights are. I wasn't here before I got what was said before I got here.
I'm telling you, if you put me in that police car right now, I will own this city.
Well, I'm not doing it because you're threatening me.
No, I'm not threatening you.
Because you're making sense.
I'm not threatening you.
You hear me? I know you're making sense.
They're searching my car right now, which is already a violation.
You know why I asked you if you're a First Amendment auditor? Because I watch these films of people exactly doing what you're doing.
I've seen them. I've never done it myself.
And you are fairly correct.
I am very correct, and I am going to own this city at the end of this interaction. They just searched my car for no reason. They have no legal reason to search my vehicle. You have no legal reason to search my vehicle. You have no reason to detain me. Unless these cuffs are off in the next 15 minutes, you all are going to be sued for illegal detainment. I would suggest you take the cuffs off. I will step to the side and let you guys investigate. But I will be uncuffed. Chief, we need to have a word. You're illegally searching my vehicle at this point. I'm telling you, you are illegally searching my vehicle at this point. It's because he got mad that I didn't ID myself because I have no reason to. I did not break any laws.
I know what you're saying.
Well,
say what? Put him in? All right. Go ahead and sit
Are you
there.
really going to do this? All right. Lawsuit time, buddy.
Just step in.
My wife died 9 years ago, and I'm just having a bad day. Today.
Right.
The anniversary of it.
Okay.
So I'm a little worked up, and I was a little irritated with them. And but I do know my rights. And
I don't mean to be mad at the lieutenant. If he wants to come apologize to me, we can walk away from that.
Well, I think the superiors are discussing it, and hopefully they'll get it all figured out in a few minutes, and we can end this.
Washington County, West Fork, State 1050.
I did 23 years in the Army fighting for everybody's rights, and I don't want to stamp on anybody's rights, but at the same time, I wasn't here and didn't witness the conversation from beginning to end. Right. You seen when I pulled up. So.
I did, and you were very cordial, and I really appreciate you understanding that.
It is unclear from the footage what was discussed between the supervisors on the scene, but Mr. Watchman was eventually released from custody, but was charged with obstructing governmental operations under Section 5-54-102. When he returned to his truck, he was unable to locate his firearm.
There's my holster. There's my carry license. Enhanced. I did the enhanced because
they must have it.
It's theft of property at this point. Theft of property. Where? It's not in my truck, and I'm not leaving until they provide me my firearm. Here is my empty holster right here.
Let me go check.
It's not. My ammo is. They dumped my ammo in the glove box.
Maybe it's under the seat or something. I think they want you to go before you get loaded.
I'm not leaving until the firearm is proven to be back in my truck. My firearm is not in here.
Oh, there it is. It's over here. It's right there. Just go ahead and roll, please.
After locating his firearm, Mr. Watchman left the scene without further incident. Following the encounter, Mr. Watchman filed a complaint with the city against Lieutenant Halfhill, and in a video posted on January 5th, 2025, Johnson City Manager Justin Eichmann told Mr. Watchman that he was not entitled to knowing the outcome of his complaint because it was considered a personnel matter. In comments left on his videos, Mr. Watchman stated that he defeated the obstruction charge in appeals court and that he intended to sue, but settled before filing for an undisclosed amount. Overall, the Johnson officers get an F for demonstrating fundamental misunderstandings of Arkansas law and civil rights, detaining Mr. Watchman based on vague suspicion rather than actual articulable criminal activity, and for maintaining a hostile and accusatory attitude throughout the encounter. It appears that Mr. Watchman was wrong about the public nature of the parking lot. The entrances were clearly marked as restricted to police vehicles and authorized personnel, and once he was personally told to leave, the officers had a strong basis to treat his continued refusal as criminal trespass under Arkansas law. The issue with their conduct is that the officers did not handle the situation with clear, consistent legal reasoning. The encounter began as a stop driven by vague suspicion, and only later morphed into a trespass theory when Mr. Watchman refused to identify himself, with multiple officers appearing uncertain about what authority they actually had and the non-public status of the lot. A voluntary encounter does not create a legal obligation to answer questions, and an investigative detention requires reasonable suspicion tied to a qualifying offense, not a generalized hunch about someone sitting in a vehicle. The officers treated Mr. Watchman's refusal to cooperate as proof of potential criminal activity and unnecessarily escalated the situation with an openly accusatory tone without fully understanding the legalities at play. As discussed before, the search of Mr. Watchman's truck is where the conduct becomes the most difficult to defend. The Gantt ruling is clear, and without Mr. Watchman having access to the area or evidence of a crime inside the vehicle, there is a strong argument that the search was unlawful. The alternative theory of a protective weapons sweep under Michigan v. Long still requires a specific safety justification and does not authorize a broad exploratory search after the suspect is secured. This interaction highlights how officers can have a valid enforcement objective and yet still create unnecessary liability when they rely on vague suspicion, misstate basic legal standards, and escalate into an unjustified vehicle search instead of just keeping the encounter narrow and lawful. Now, Mr. Watchman gets a B- because although he was correct about the identification issue and allegedly followed up this interaction with the proper legal action, he failed to invoke his right to remain silent at any point during the encounter and demonstrated a highly consequential misunderstanding of both Arkansas's trespassing statute and the non-public status of the parking lot. As mentioned before, the lieutenant's initial initial quote-unquote suspicious activity framing did not align with Arkansas Rule 3.1, which requires reasonable suspicion tied to a felony or a qualifying dangerous or property-related misdemeanor before an officer can escalate into a detention. Mr. Watchman's focus on whether the lieutenant was alleging a misdemeanor or a felony usefully exposed that gap, and the lieutenant's inability to articulate a specific qualifying offense strengthened Mr. Watchman's position on the identification dispute. However, Mr. Watchman's strongest point was paired with his most consequential error. As discussed before, Arkansas criminal trespass applies when a person purposely enters or remains unlawfully on the premises of another, and to quote-unquote enter or remain unlawfully includes entering without license or privilege and remaining after an authorized person personally communicates an order to leave. With the lot posted as restricted and Lieutenant Halfhill ordering him to leave, Mr. Watchman's insistence that the area was public and that he could remain there was not a defensible position, and it created an obvious path to a trespass arrest that he did not appear to adequately account for. Mr. Watchman also failed to invoke his right to remain silent and engaged in far too much debate with the officers. Even when a citizen correctly interprets the law, prolonged argument and unnecessary explanations tend to expand the encounter, increase the chance of escalation, and provide officers with more opportunities to reframe the situation later in court. While I do commend Mr. Watchman for standing up for his rights and following up this encounter with the proper legal action, I would caution others in a similar situation to fully assess the practical aspects of the situation before getting caught up in the legal nuance, and to exercise the right to silence whenever possible. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in exploring the legal nuance beyond the body cam.